Good afternoon, Professor.
Yes, ma'am.
Good
Yes,
afternoon.
ma'am.
Thank you, everyone. Good afternoon, Professor Dr. Nishtha Jaswal, Honorable Vice Chancellor of Himachal Pradesh National Law University, Shimla. Professor Anand Shankar Singh, Principal, Iswar Saran PG College. Mr. Gauri Gulati, Founder and Managing Director, Droit Penale Group, a unit of Arjun Gulati Memorial Society, and all the participants. I, Gauri Gulati, welcome you all to the day 3 of 15 days online refresher course organized by University of Allahabad in collaboration with Droit Penale Group, a unit of Arjun Gulati Memorial Society. For the third session, we have Professor Dr. Nishtha Jaswal, Honorable Vice Chancellor of Himachal Pradesh National Law University, Shimla. Professor Nishtha Jaswal has been appointed as the first woman Vice Chancellor of Himachal Pradesh National Law University, Shimla. Chief Justice of Himachal Pradesh High Court and Chancellor of Himachal Pradesh National Law University appointed Dr. Nishtha Jaswal as Vice Chancellor for a tenure of 5 years. In a first of its kind, Dr. Nishtha Jaswal and Professor Paramjeet S. Jaswal, Vice Chancellor of Rajiv Gandhi National Law University, became the first couple to be Vice Chancellors of two national law universities at the same time. A gold medalist and academician, Dr. Nishtha Jaswal has a teaching experience of 33 years and research experience of 35 years. She specializes in constitutional law, administrative law, human rights, and environmental law. She has over 65 research papers and 6 books to her name. Her book, titled Environmental Law, has been cited thrice by the Supreme Court of India in the landmark judgments. Nishtha Jaswal has been designated as Meher Chand Mahajan Professor of Law by Punjab University, Chandigarh. She has served Punjab University, Chandigarh in various capacities. She remained the chairperson, Department of Law, Punjab University, Chandigarh. Dr. Nishtha Jaswal has a wide range of administrative experience. She has served as member of Chandigarh Commission for Protection of Child Rights, Punjab Legal Service Authority, Advisory Committee of Institute of Correctional Administration, Chandigarh, State Level Authorization Committee of Punjab under the Transplantation of Human Organs Act 1994 and Advisory Committee, Nari Niketan, Chandigarh. She is also a member of Board of Studies and Academic Council of Central University of Punjab, Bhatinda, and Rajiv Gandhi National Law University, Punjab, University Institute of Legal Studies, Punjab University, Chandigarh, IMS University, Dehradun, Himachal Pradesh University, Shimla, and Kurukshetra University. Dr. Nishtha Jaswal was also awarded British Academy Visiting Professorship in 1992. Ma'am, we feel honored to have you with us. Now, I would request ma'am to proceed with the lecture. The topic for today is Human Rights Teaching in Law, National and International Perspective. I would request ma'am, you are on mute. Kindly unmute yourself.
Okay. Thank you, Beta, and good afternoon, all. I am really fortunate to be one among you today, and topic is also very good. Most of the times we think that we can teach this topic very well. This is a very simple topic. Well, this is not so. This is the topic which touches our heart. And till the subject touches our heart, we can't teach it. I can start by quoting Justice Krishna Iyer. He once said, "What were my guiding goals I try to practice on and off the bench?" So my first advice to all the teachers present here is, whichever subject you want to teach, first make it part of your heart and soul. This is really true about at least human rights. First thing, before you want to teach human rights, you must know what are the human rights. And you must be able to communicate to the students what are human rights. We define human rights under the Protection of Human Rights Act also, which says human rights means rights relating to life, liberty, equality, and dignity of individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Now, this is the definition under a law. But I would like to quote Mother Teresa when she said, human rights are not a privilege conferred by government. They are every human being's entitlement by virtue of his humanity. Each and every word speaks for itself. Don't you have human rights? As a person, as Mr. So and so, Miss so and so, Mrs. so and so, Dr. so and so. Don't you think when you're teaching in the class, every student sitting in the class has human rights? So when we talk about human rights, first of all, we have to think about from the angle of every individual. Think as individuals and let your students think as individuals. Whether they understand what are their rights, human rights. We are in India, we have fundamental rights. All the fundamental rights are human rights, but all the human rights as prescribed globally may not be part and parcel of our constitution. So first of all, you must learn to love yourself. And the first lesson you have to give to your students is that they must love themselves. Of course, when I'm talking about love, this is not narcissism. This is altruism. You are loving yourself, but not at the altar of the family, the society, the nation, and nowadays we cannot restrain ourselves to any boundaries. In fact, we the Indians never restrained ourselves to any boundaries. We have always believed in Vasudhaiva Kutumbakam. If this lesson is imparted successfully to the students, you crossed a barrier and you are ready for the show. Then you must understand that we, the people of India, have certain rights. At this juncture, you must ask yourselves a question and raise the question before the students. Will you be able to enjoy and exercise your rights without performing your duties. So, performance of duty means making it easier for others to enjoy their rights. This is the next step. If understood from the deepest core of your hearts, you have crossed another threshold. You pass on to the next. You are teachers. You're the future makers of this country. I'm not here to teach you human rights as such. I'm here to guide you from my experiences how you can impart this human rights education. So, as teachers, your first step for teaching after inculcating the values, you have to develop a curriculum. Curriculum development is very, very important. You may have one paper on human rights, or you may have paper on human rights as well as different papers on like women rights, child rights, or anything dealing with the scheduled caste, scheduled tribe, disabled, any such issues which pertain to every human being. So you have to frame the syllabus or syllabi. Depending upon the policy decision, your academic bodies, you have to select the number of modules. Of course, the first module, if the subject is simply human rights, the first module must contain historical aspect, must contain conceptual aspect. What are human rights? There may be different views, different schools of thought about human rights. Then one module you can devote to international conventions, Universal Declaration of Human Rights. Next module can be on the Constitution. Depending upon the number of modules, you can add any number of laws pertaining to protection of human rights. There are so many laws regarding child rights, women rights, rights of disabled persons, SC/ST Atrocities Act, and so on. If you have separate papers also like on child rights, women rights, you have to follow the same model. One module devoted to historical development, concepts. Then you can divide into, after dealing with the constitution, different legislative measures. Taking a pause and coming to the practical aspect, what to teach, how to teach, what is to be included, you have to be updated. I would like to make a reference to one more thing, which is very, very important nowadays. We can't confine our legal education merely to theoretical perspective. There is no second opinion that substantive laws have to be taught Because unless and until we are clear with the concept, unless and until we know about the provisions, unless and until we know what are the rights, we can't give it a practical shape. Most of the times, our complaint is, especially youth teachers, must be facing this complaint from the students that why you are telling us about a paper promise? We want a tiger with real teeth, a tiger which can roar, a tiger which can pounce upon whenever there is a violation of human rights. What I want to tell you is that there can be teaching of human rights through different methods, not merely classroom teaching, telling your students to open any beer act and you're teaching, you're just quoting the case law. Of course, case laws are to be taught. You can tell your students to come prepared with a decision of the Supreme Court, which is very, very important on the issue of human rights. And then you discuss what are the issues, what are the arguments, why the decision went in favor of particular arguments, what are the consequences. Are we really getting protection out of this judgment? Whether this judgment has been implemented, whether this decision has been incorporated in the legislation so as to make it more effective? Of course, there can be interactions through this method. Then there may be a role playing by the students. Now, this can be done through your legal aid clinics, your cultural committees. There may be simulation, there may be seminars, there may be debates. Even your the projects of the students can be based on some kind of interviews, case studies, some through some empirical method using questionnaires. See, my dear participants, the listeners, that a complete research project may be ready after the research is done by your students. Never underestimate your students. They are always keen to work very hard. And then you let them go to the field and deal with the real life situations. We can take the example of the present crisis. All of us are in panic, stress, suffering because of COVID-19 pandemic crisis. See, so many students, especially from national universities, they help the migrant workers who are stranded at different places, who are suffering because of many reasons. This may be a time-based problem, but the problems continue. Many a time there are disasters, and many people need our help. Can't we say that they have the human rights and we don't have to leave it to the state only, thinking that state is a welfare state and it is a duty of the state to provide all kind of support? We have to join hands with the government also. Many a time we leave everything unnoticed. Maybe adjoining our residence, maybe while going, we are just going for shopping and we see on the roadside small huts made by the construction workers. We know under the Construction Workers Act, state is under a duty to provide certain facilities to them. Now the question is, are they being provided all these facilities? Now we have to awaken to all this. We have to prepare our students for pro bono activities. Role of a teacher who's teaching human rights is very, very, very important. Now we talk about another aspect before I touch few aspects of human rights, telling you what is the mode, how you can make it interesting also. You are teachers, some of you must be still on pursuing your PhDs, some of you must have completed, and those who have completed, they might be supervising some some of the research projects, PhDs, term papers, dissertations. Now here again I can appeal to you that while guiding, always follow the research design, and when the topic is relating to human rights, of course we have to touch it jurisprudentially, but at the same time make it a non-doctrinal study so that we come to know about the causes behind the violation of human rights, and of course we can draw conclusions to control such violations. In this manner, law teachers as well as law students can contribute to the society. Now, coming to the aspect of teaching, teaching this subject. Of course, you cannot ignore the international scenario. When I told you about the definition under Protection of Human Rights Act 1993, it also refers to international covenants. Of course, you have to teach Universal Declaration of Human Rights, all the articles of Universal Declaration of Human Rights, and you have to touch International Covenant on Civil and Political Rights 1966, International Covenant on Economic, Social and Cultural Rights 1966. You teach these covenants. You teach Universal Declaration of Human Rights. If you just teach it and leave it, of course you will be covering each and every article, explaining it to the students. You may talk about the background, why these were there. In order to make the students understand and comprehend in a better way, you have to compare the Universal Declaration, the international covenants with the Constitution of India. It serves many purposes. In the sense, we come to know to what extent we are also enjoying formally the human rights which are contained in Universal Declaration of Human Rights or other international conventions. And at the same time, we can enjoy and admire the role of the Supreme Court of India that even though we could not include, the framers of the Constitution could not include all the human rights at the time when the Constitution was framed, but the Supreme Court of India has, through interpretations, included almost every right. You name any right, and this is part and parcel of fundamental rights. As the task was performed by the Supreme Court of India. Like you can tell your students that the core of our fundamental rights is dignity. In fact, the widening of scope of Article 21 of the Constitution is because of the interpretation by the Supreme Court that right to life includes right to live with human dignity. We have so many cases on the points. Like I can refer to PUDR versus Union of India, where the Supreme Court talked about minimum wages to the Asiad workers and clearly said right to life includes right to live with human dignity. I can refer to Francis Corelli Moline versus Delhi administration of 1981, where when the Supreme Court referred to the prisoner's right to meet family, to meet friends, to have relaxing period, it was merely on the ground that right to life includes right to live with human dignity. There is no dearth of cases talking about this human dignity. Now, here, immediately you can refer once again, reminding the students that you studied UDHR. The preamble of the UDHR talks about human dignity. And see how, through this concept of human dignity, we refer to all kinds of rights, whether child rights, women rights, or rights of any person. Because if we refer to Article 21, it is guaranteed to any person. Similarly, you're talking about Article 3 of UDHR. This is just similar to Article 21, right to life. You're referring to Article 9, which is similar to Article 22, protection from arrest and safeguards from arrest and preventive detention laws. Articles 19 and 20 of the UDHR are similar to Article 19 of the Constitution of India. Right to privacy was read into Article 21 in right to life through judicial interpretations. Well, there was already a provision, Article 12, under UDHR. Now, there's no dearth of examples. My purpose was simply to tell you that this is how you can teach this international perspective. I want to tell my dear students that otherwise, when you are teaching merely the provisions and provisions, your teaching becomes monotonous. And to bring a color to your teaching, you have to innovate new ideas of teaching. Now, I just refer to the Constitution, which is the temple, which is the treasure containing the human rights in the form of fundamental rights. When you're starting with the chapter on part third, the topic on part third of the Constitution, Before that, you must tell them that every right has a correlative duty. You can remind them of Hofeldian concept of rights and duties. If you have a right, other person has a correlative duty. And you can innovate by telling them that, of course, it is not you only who has to perform the duty. It is the state also to perform the duties and responsibilities with the help of the guiding principles under the Constitution, that is, directive principles of state policy. When the students join law, especially in 5-year integrated courses, they are also taught the social sciences subjects. And before studying constitution or human rights, they have already studied the subject like sociology. Now they have to be told that you find in elaboration the practical and legal aspect of this sociology, because your fundamental rights, your human rights, exist in the society with the help of society for performing your social responsibilities, for protecting the social interests and rights of the people, so that there is no social anarchy. No doubt, when we refer to the Constitution, the fundamental rights are guaranteed against the state. Article 12. But I must tell you, in certain cases, this can be raised against the individuals too. When I refer to use of public places, I hope you can be reminded of Article 15. When I refer to Article 17, you can't practice untouchability. When I refer to no exploitation, no begar, at the same time, even if guaranteed against the state, it's not that always the state is the violator. State may not be the violator, but state has to be the protector of your fundamental rights, that nobody can violate your fundamental rights. If you have a fundamental right to life, no individual can violate it. State is under a duty to protect you. Immediately, I can remind you about equality. In fact, we are very fortunate that when we open our constitution, the preamble also talks about equality, equality of status and of opportunity. Equality. In what is equality? Now you have to tell your students. Expectation of your student may be that 2 plus 2 is equal to 4. But you'll have to tell your students that when we talk about the concept of equality, which is the most important human right, most important fundamental right, here 2 plus 2 may equate to 3 or 5 or 6. When we talk about right to equality, It means equals have to be treated equally. You have to tell them the concept of equality, because in the concept of equality is imbibed your principle of rule of law. And what is principle of rule of law? That is anti-arbitrariness. No, it's not that you simply start with article. This is the language of Article 14. Of course, you have to tell the state shall not deny equality before law and of law in the India. Absolutely right. You have to tell them about the test for this equality, that there can be classification, but classification has to be reasonable. And then what are the two tests for reasonable classification? Must be founded on uh, intelligible differentia, and there must be rational nexus with the object to be achieved. Now here, you have to exemplify, you have to illustrate beyond the decided cases. You have to tell them, if we are making special provisions for children and women, they come within a bracket. This is an example of reasonable classification, because they can be distinguished from those who are not part of the group, and there is a rational nexus to protect them. Or when we talk about the weaker sections, to uplift them so that they come in the mainstream. Like I give you the example of, when we talk about right to education, we talk about special provisions for EWS category students in the schools. They form a class by themselves. There may be social criteria, there may be economic criteria, and only then they can understand the concept of reasonable classification. Then, of course, there's no dearth of the case laws. You have to teach them the case laws. You have to tell them Air India versus Nargesh Mirza, how womanhood and motherhood has to be protected. How this was discriminatory. Males and females performing the same kind of duties. How can you say that female will be removed from the services after becoming a mother? And the same is not the case with the male counterparts. I can see some comments, some questions, but my request to the participants, please note down your questions, and I'll give you half an hour for interaction. I'll try my best to satisfy all your queries. Now, this island of equality is spread starting from Article 14 to Article 18. 14, we talk about general right to equality. We have so many instances. In order to understand, I give you one very interesting example. There was a decision of 1990, Bhagwanti versus Union of India. Question was of payment of family pension. Now it's a question of human right of everybody. Now, human right of the person who was serving, human right of the family was to receive the family pension. The service rules provided that family pension will be paid only when the employee was married before he superannuated. One way of teaching is you simply tell them these are the facts of the case, and the court decided that the rules are discriminatory, arbitrary, that's all. But you have to tell the students that it's not that the rules are arbitrary like this. You question it. What is the meaning of family? Family means dependents of the employee who served till he attained the age of superannuation. He was receiving pension, he died, now the family will get the family pension. Family means the family, whether family emerged before the retirement or after the retirement. How does it matter? Article 14, when we talk about any human right, in fact, the most important is where we find the living abode of rule of law. No arbitrary exercise of power. And whenever under any law, many a time we find one term or one principle, like I can refer to JJ Act regarding children, the best certain principles for the protection of children, which were taken from the International Convention on Child Right of 1989. One principle which contains almost everything, that is best interest of the child. What is in the best interest of child? If I take away the word child and say best interest of human beings, you'll say they must be allowed to enjoy the natural rights. You will say that there should not be any discrimination when they have to enjoy their human rights. What is arbitration, arbitrary exercise, and what is discrimination? This is nothing but the way you exercise power. Principle of power is understood well by those who are teaching administrative law principles. One thing is clear, power has to be exercised, but power has to be exercised for the purpose for which the power has been vested. There must be control on that power, on the exercise of the power, that only relevant considerations will be considered and extraneous considerations will be ignored. Now, you might not think in these terms when you are teaching the human rights. I can give you one clue how you have to correlate different aspects. Person has committed any such offense for which he might have to be hanged. Right? Or any other action has to be taken against him. Death sentence is announced, he files mercy petition. Number of situations. Mercy petition remains pending for years. Can you imagine the impact? Whether a life convict or a convict waiting for death sentence ceases to be human being? Answer is no. Now here, in fact, again, the Supreme Court played a very, very important role. I can remind you of number of cases like Saran, Sher Singh, Javed Ahmed Pavla, and ultimately leading to Shatru Singh Chauhan's case, or V. Hariharan's case of 2014. Whenever there is delay in the execution of death sentence, undue delay in the execution of death sentence, it can be converted into life imprisonment. See how we can talk about the human right. Or you have filed a mercy petition. Now, how the mercy petition is to be disposed of? In picture is the applicant, the person who has made this mercy petition, and the decision is to be taken by the governor or the president, as the case may be. File is produced before the governor, governor decides. Now here, I can just remind you of one decision of 2000, Satpal versus State of Haryana. What happened? Remission was granted. To whom? To a person who was not even in the jail, who was not even arrested. He received the release orders, surrendered, and he was relieved. Now here, it is not a question of human right of a person undergoing sentence who had committed a crime, but also of the victim. We have to think about the victim. It is victims' human rights also. And when questioned before the Supreme Court, it was found relevant considerations are not placed before the Honorable Governor. So that is why I talked about the concept of power. Now this submission was quashed and it was sent to the governor for reconsideration. And it's a practical aspect where we don't think in terms of human rights. Equality, we know it is, I don't have that much time that I talk about every aspect of equality, including reservation. Now, I just want to pass on to the freedoms. We have so many freedoms. We had 7 freedoms under Article 19, but after right to property was taken away by 44th Amendment Act 1978. There remain 6 freedoms only in Article 19. But I would like to tell you in the year 2013, in Tukaram's case, Supreme Court went to the extent of saying that right to property may not be a statutory or fundamental right, but it remains a human right. And here only, I must remind you of a decision in 2010, the case of Ramdev Chauhan versus Bani Kanti Das, decided by the Supreme Court. Supreme Court went to the extent of saying that some rights are due to you because of certain provisions of the law and you are not provided those. Some benefits which you are supposed to get, there is a violation of human right. I can refer to very, very important human right. Freedom of speech and expression. As I told you, this is part and parcel of Universal Declaration of Human Rights. And even before opening our part 3rd of the Constitution, If I just open the preamble, we find liberty of expression, belief, faith, and worship. What kind of right it is? It is not an absolute right. It is subject to reasonable restrictions, and reasonable restrictions are mentioned under Article 19, Clause 2. Whether we talk about prisoners' right to speak, give an interview, like we have the decisions of Supreme Court in Prabhudat versus Union of India 1982. We have Charulata Joshi's case of 1999 by the Supreme Court. We have a decision by M. Hassan versus Government of Andhra Pradesh 1998, a decision by the Andhra Pradesh High Court. Basically, we recognize the rights of the prisoners to give interview if the prisoners give their consent and if the prison manuals so provide for. But of course, whatever is provided in the prison manual or any law has to be fair, just, and reasonable. We may talk about this freedom of speech and expression complete only when we have right to know or right to information. I hope you understand. I want to remind you, when you are talking about this right to know, you cannot forget SP Gupta's case. You cannot forget other cases, and immediately you have to tell your students that because of this freedom of speech and expression, we had Freedom of Information Act 2002 and then Right to Information Act of 2005. Right to information or right to know is very, very important. I can refer to SP Anand's case, I can refer to Dinesh Trivedi's case, where in these cases the issues are regarding what happened in Kargil infiltration, the report we disclosed, which was placed before the parliament. Now, I just told you no right is absolute right. Here, you can refuse this on the ground of security of the nation. There are a number of tests. I can't go into that much detail about every aspect, but just to tell you, the one of the grounds are this decency. Decency, in fact, has changed the concept. Udeshi's case, Avir Savarkar's case, total, we have changed from the test to the community interest test. So you have to be very, very clear about these tests. Nowadays, controversy is still going on the question of sedation. Sedition. Sedition is whether this can be a ground for curtailing this freedom of speech and expression. Now you have to invite such debate from the students. Such debate will help you. In fact, most of the top class legal institutions, they have received the um, request from the government to give suggestions for making amendments in the criminal law. For these criminal amendments, meetings are going on. And this is one of the aspects where we have to think and decide to what extent our freedom of speech and expression can be curtailed. Automatically, in this freedom of speech and expression, we include the media rights. And in the media nowadays, we do talk about new media. It's not merely print media, electronic media. We do talk about social media, which is much, much stronger than any other source. And I cannot go in detail. I'll say once again, I can just refer to you Shreya Shingal's case of 2014 on declaring Section 66A of IT Act as unconstitutional. Number of other freedom of association, residence, moving freely, carrying out in trade, occupation, business, of course, subject to reasonable restrictions. I can't touch each and everything. I'm coming to the gem of fundamental rights, a right to life. Article 21 of the Constitution. I want to tell you the background. When the Constitution was being framed and Article 21 was to be incorporated, lot of discussion took place in the Constituent Assembly. Main issue was whether to incorporate American due process clause. It was deliberated upon and ultimately it was rejected, and we use the term procedure established by law. No person shall be deprived of his life or personal liberty except according to procedure established by law. Perhaps there was fear in the minds of the framers of the Constitution that if they incorporate American due process, state being welfare state, there will be flood of litigation. We rejected it when we framed the Constitution. We traveled from 1950, A.K. Gopalan's case, to Maneka Gandhi in 1978. Maneka Gandhi, the main question, main human right or fundamental right to travel abroad. Her passport was impounded because she was required to appear before a commission of inquiry. Her passport was impounded without even giving her chance of representation. Naturally, this was questioned. The Supreme Court could have easily declared the Passport Act, Section 10 of the Passport Act, which gave this wide power in the hands of the authorities, as unconstitutional. But this was not done because a promise was made by the government to give post-decisional hearing. How this concept of human rights developed? Now, this was the stage when we imported procedural due process from America, which we rejected when the Constitution was enacted. But still, we did not incorporate substantive due process. This was only in 1983 in the case of Mittu versus State of Punjab, where Section 303 of Indian Penal Code was declared as unconstitutional. So widening the scope of Article 21 and then talking about that right to life includes right to live with human dignity. You name any fundamental right, that is part and parcel of right to life. We may refer to Khadak Singh, Govind, how the interpretation of right to life changed, going beyond the animal existence. Lot of discussion, a lot of traveling and journey till we finally talked about right to privacy as a fundamental right. Starting Khadak Singh, Govind, or we talk about number of other cases, and MP Chandra's case, then of course R. Raja Gopal case, this Auto Shankar case of 1994, where we talk about Mr. X versus Hospital Z. We talk about State versus Madhukar Narayan, where we talked about the right to privacy of a woman of easy virtue. We reached that day when K.S. Puttaswamy was announced, and ultimately, right to privacy had good hold on the ground as a fundamental right. Similarly, we talk about other fundamental rights. I can just refer to very important fundamental right as a human right. We cannot enjoy anything unless and until we know about it, unless and until we are aware of it, unless and until we are educated to understand it, unless and until we are educated to participate in the governmental functioning so as to convert governance into good governance. I'm talking about right to education. 1992 and 1993, Mohini Jain's case and Unni Krishnan case. Unni Krishnan clearly talked about right to primary and education as a compulsory education. And then I can refer to 86th Amendment Act 2002, which included this right to education as a fundamental right under Article 21A. Not only this, even there was change in Article 45 for creating a duty, and at the same time, 11th duty was added in the fundamental duties part 4A, which was added by 42nd Amendment Act 1976. Right to Education Act was also passed as a consequence. And we find so many changes. The efforts which can be made for making this right to education a living reality. I can refer to a number of other very, very important rights, and sometimes I feel it's a mockery of the situation that there are certain natural rights. Isn't it a natural right? We must have food to eat. Why? In PUCL's case, it was to be declared by the Supreme Court. We talk about right to clean drinking water. Why this was done in 1996 Delhi water undertaking case? Again, it's so pinching that I can discuss with you this case, how there was a conflict between Delhi and state of Haryana for sharing the Yamuna waters. Supreme Court said it is really, really hurting that state of Haryana is using water for industrial purposes, and people in Delhi, they cannot satisfy their thirst. So directions are issued that first of all, the water tanks in Delhi will be filled up, and then water of river Yamuna will be used by state of Haryana for other purposes. I can talk about right to shelter. Now, God bestows upon us this life, and all of us know that we have some basic necessities, roti, kapda, and makan. Still, I can refer to Chameli Singh's case of 1996, where Supreme Court had to say that right to shelter is a fundamental right, and right to shelter does not mean four walls and one roof. It means a place where every person has a right to develop individually, socially, economically, psychologically, emotionally, and whatnot. And right to livelihood. I would like to refer. Article 43 does talk about this right to work, but that is a directive principle of state policy, and all of us think that this cannot be enforced in any court of law. Even though we have crossed that stage and we say there are fundamental rights and directive principles are, complementary and supplementary. And these directive principles of state policy have been raised to a status of inalienable fundamental rights. Right to livelihood. I can remind you of Olga Tellis. I want to go beyond Olga Tellis. Sudan Singh, where hawking and non-hawking zones were made by the Supreme Court. I can remind you of Delhi Horticulture Employees Union case of 1992, where Supreme Court had to tell, understanding the restraints of any government. Supreme Court said, of course, right to livelihood is a fundamental right, but this is conditional. This is subject to economic capacity and economic development of the country. I go beyond this. Really surprising. Now you have to imbibe these values among the students and tell them we don't have to be rigid in our thinking, obsolete in our thinking. We have to rise above many notions which are backward. I'm referring to a natural right. Still, we have to knock at the doors of the Supreme Court to declare it as a fundamental right. I'm talking about right to marry. Lata Singh's case of 2006 and Arumugam Sirvai of 2011, where the role of the Khap Panchayats were condemned. This is beyond imagination, in fact. There are many rights. I can't touch each and every right in such a short duration. But still, I would like to talk about many. I can refer to very, very important human right. That is prisoners' rights. Who are prisoners? Anybody will say who is put behind the prison. Then the question is whether they cease to be human beings when they enter the gates of the prison. Answer is no. I may quote Justice White, Justice Douglas of American Supreme Court. And I can also quote Justice Krishna here. When he talks about the dignity of the prisoners, that they don't cease to be human beings once they are incarcerated. Of course, they have the limited rights, but they cannot be denied the rights, except which are restricted because of their being in the prison. I can refer to number of rights. I refer to their rights to give interview. I can refer to their right to live with dignity within the prison. They need not to be tortured. I can refer to this Kishore Singh's case of 1981. We can refer to Sunil Batra cases. There are two Sunil Batra cases. Sunil Batra versus Delhi administration 1978 and 1980, where the Supreme Court did talk about they should not be put in solitary confinement. Meeting the camaraderie is a bliss. We should not be put behind the bar fetters. They should be allowed to commingle with other prisoners. Under trial prisoners and hardened prisoners should not be kept together. Nowadays, we have open prisons with recognition of many of the fundamental rights. I can refer to one very, very important decision of 1997 Ramamurthy versus State, where 9 vices in the prison were brought forth before the Supreme Court, like overcrowding, bad food, torture in the prison, and number of other vices. And one very, very important psychological question was to be tested, that why the thread of conjugal rights be broken, because this is one of the reasons for committing sex crimes. Hygiene, clothing, all are in question. Gone are the days before Maneka Gandhi we could talk of law as merely enacted law and not which includes rule of law or principles of natural justice. We have passed through the stages where the Supreme Court had to direct against use of handcuffs. Prem Shankar Shukla's case of 1980. Justice Krishna Iyer very rightly said, handcuffing is cruel, inhuman, and barbarous, and it can be used only in the rarest or rare cases when you have no other option to prevent their escape. These directions are given in 1980. This misuse of power went on and on. Sunil Gupta's case, where certain social agitators, they were handcuffed, they were sitting silently in dharna. I can refer to Re-MP Dwivedi of 1996. Just imagine, when the matter reached up to the Supreme Court regarding this handcuffing, Supreme Court questioned the police officers, don't you know about the judgment in 1980, Prem Shankar Shukla? They were not aware of. Even the judicial officer before whom the person was presented while handcuffed was not aware of this right, the directions by the Supreme Court. Now, this was placed in the personal file of the judicial officer and reform started. Supreme Court directed that all the judgments to be sent to all the police headquarters to be distributed further, even for the orientation of the judicial officers. Now, this orientation is really required. I can remind you of one decision in 1991, Delhi Judicial Officers Association's case. How and what it happened that in Nadiad in state of Gujarat, one judicial officer was handcuffed by the police officials and while handcuffed, paraded through the streets and taken to the police station. This was taken as contempt of court. I'm not talking about contempt of court, I'm talking about violation of human right. We were not born in chains. Even if committed some wrong, you have to teach your students to use 4 W's and 1 H. That if you are future lawyers, judges, police officers, bureaucrats, and what not, think of what, why, when, where, and how. If a crime is committed, of course the victim is there. But why? A person who is in his senses, who was taught values, he or she committed this crime. What were the circumstances? That is why under the Indian Penal Code we have the chapter on general defenses too. We have to think in these terms. Nowadays, we do talk about releasing on parole, releasing on bail. Bail is not a matter of right, but we have to protect the human rights. Everybody has a human right to defend oneself. Some legal obligation is there. You land into a court of law, you have the human right to defend yourself. In this context only, I talk about this right to bail. Old case of Baburam of 1978. Enmity between two families. The male members of one family committed murder of all the male members of other family, and they were behind the bars. And the females, they were illiterate, who did not know ABC of bail, who did not know how to approach any lawyer. I hope you understand. This is the situation where it becomes so important to release them on bail. I'm not talking about giving up bail in the cases like Pappu Yadav, where Supreme Court categorically talked about not to issue bail. Apart from this, we have the decision on the position in this is inhuman conditions in 1382 prisons. How the directions were issued to frame the modern jail manuals, releasing of the prisoners, maintaining hygiene and providing other facilities, how regular inspections have to be made in the prisons. And on this basis, on the directions issued by the Supreme Court, of course, we will be modern in approach, recognizing human rights of not only the accused, but also the victims. I can refer to again, not in detail, just Article 20, safeguards to the person arrested. Ex post facto laws, protection from double jeopardy, protection from self incrimination. Self incrimination, immediately I'm reminded of Selby's case, where we do talk about mental privacy and not to apply all those tests for investigation, polygraph, etc. And at the same time, I can remind you of common cause case of 2017, where we do talk about, because this Aruna Ramachandra Shanbag's case, the cases where we, in fact, in the real terms, we talk about right to life. Right to life when you are in a dead stage, just in coma, you are in a vegetable stage. What should be done? I can refer to Aruna Ramachandra case, where we recognized passive euthanasia. I can refer to common cause, where we went a little ahead. Even though in Gyankor we did talk about that right to life does not include a right to die, but in common cause we did talk about right to die with dignity. Thus, we have human rights from the day we take birth till we die. Death, dying in respect. Now, here I can remind you of the question of public hanging in Dina's case, and Supreme Court said this public hanging is barbarous, inhuman, and cruel and cannot be resorted to. The question was before the Supreme Court in Lakshma Devi's case about that this hanging is barbarous. So we must adopt some other method. Efforts are made, and no other way of awarding death sentence was found as less cruel. It was taken the least harmful. Instances are many on many issues, like in the present times. I can refer to number of issues which were in discussion, like release of prisoners so that the corona doesn't spread because of congestion in the prisons. Very good step. Of course, aftermaths are there. Society may not accept those prisoners, and all the prisoners, hardened prisoners, cannot be released. I would like to refer to one very important human right, also a fundamental right. We do talk about right to justice. Justice, what is right to justice? Right to justice means that we should be able to protect our rights. Once we have questioned it, there must be a fair trial, and not only fair trial, there must be speedy trial. Right to speedy justice. We have so many cases starting from Husainara Khatun, Bhagalpur blinding case, and till date we have been talking about all these decisions. I can just refer to one decision of Anil Rai in 2001. Now here Supreme Court directed within how much time the civil cases, the judgment to be delivered, how much time the trial to be completed in criminal cases, how much time the decision to be given, keeping into account all the eventualities. At the same time, talked about the delay in the delivery of judgments at the High Court level. We are aware of the instances where many a time the judges, they deliver judgment just on the day of their retirement because they have to. The consequences are grave. Grave in the sense, I keep a pause, and I'm telling you, your student may ask you, I did not commit any wrong, but the university decided to rusticate me. I'm no more a student. I challenge it before a court of law. And it takes years and years. I know. After that, status quo cannot be granted. Where do I stand after that? Justice should not only be done, but must also seem to have been done. So that is why there's a need for speedy justice. In Anil Rai's case, Supreme Court directed that when a judgment is delivered, the date of delivery and when it was reserved, all the dates will be mentioned on the front page. And if there's a delay of 1 month, a reminder will be sent to the bench. 2 months, if application is there by the petitioner for delivery of the judgment, will be considered within a specified time. After 6 months, the bench may be reconstituted. Even though I don't agree, again there will be delay. But of course, we have to make this right to speedy justice a living right. Only condition is you have to teach your students that they have to inculcate all these values, they have to imbibe these decisions in their hearts so that tomorrow, if they are judges, we must know what is the law, what are the rights, what are the human rights. Of course, we want to live and stay healthy life, especially in the COVID-19 pandemic. We are talking about our physical health. We want to live healthy, we want to live safe. Again, a very important role has been played by the Supreme Court. As such, we don't have any fundamental, specific fundamental right. If we count all the fundamental rights, where we can say right to health is a fundamental right, we find a touch under 39E and F that we have to protect the health and strength of the workers. But can we have right to life? You'll say yes, we are living, we are breathing. It's not quantity, it's the quality life which we want to live. And I can tell you about the situation from where we have grown. I can refer to the case of Permanent Carter of 1989. There were times, in fact, it should not happen with anybody. Somebody meets with an accident on the road and you're crying for help. Somebody comes and say, first you call the police and then we'll take him to the nearby hospital. And then whosoever comes for help will be harassed later on. And at that juncture, it may happen you lose your near and dear one. The Supreme Court said it is the duty of every doctor to give first aid and whatever treatment can be given. No doctor can take an excuse that he's not specialized in this. Now, what happens if you take any this accident victim to a doctor or just a nursing home, private nursing home nearby, and the doctor tells you, I am a gynecologist. At least every doctor, whatever specialization may be there, can give first aid before the victim can be taken to the hospital. I was just reading on the screen the question of not getting bed. Yes, it is a problem. It is a peculiar problem during this corona period. The serious patients, they are not getting beds, they are not getting the treatments, even though the government is trying its best. I can remind you of one very, very important decision in 1996, Paschim Banga Khet Mazdoor Samiti's case. One laborer, he fell from a moving train, had injury, taken to the government hospital, same problem. Not admitted with the plea that no bed is available. Life was to be saved. Life is more precious than all these excuses. He was taken to a private nursing home. Treatment was given. He could be saved. Thank God. Now, here the Supreme Court directed to pay him not only the cost but also the compensation and declared this right to health as a fundamental right. There are so many decisions on this point, even on right to medical reimbursement, that is also part and parcel of right to health, which is part and parcel of right to life. And we have so many cases where occupational hazards to health are there. Like in Consumer and Education Research Center versus Union of India. Now here, just imagine those who employ, they know what kind of industries they have, what kind of effect on the employees, the workers, the laborers will be there. When permissions are granted, complete laws are made applicable, how their medical insurance is to be done, how regular periodical medical checkup has to be there, for what precautions have to be taken. Like we can see the best example, the COVID-19 pandemic period, doctors are the most affected. Police officers who are on the duty round the clock are most affected. Doctors, They're taking all the precautions to their best. The hospitals providing them with all kinds of safeguards and precautions. This is what is required. Now, here in that particular industry, people died after some time. They knew they are going to die because precautions were not taken, regular health checkups were not there, medical insurance was not there, irrespective of the fact the directions are there. Now, again, directions are issued, and here again I can see one question. Not to disclose the identity. Of course, this is your natural right. And this is part of right to privacy too. That even if your name is in the record of the hospital, what disease you are suffering from, it is not to be disclosed. This is part of medical ethics. But I can tell you something else. Sometimes we have to weigh, put on the balance. On the one side, right to life. On the other side, this right to privacy. I can refer to one very, very interesting case of Mr. X versus Hospital Z. Here, what happened? One Mr. A, he went for a treatment to a particular hospital. He needed some specialized treatment, so he was sent to some other specialized center where one of the doctors was also asked to accompany him. There, the patient needed blood. We must appreciate the doctor offered to donate blood. When the doctor donated blood was tested, it was found HIV positive. Now, this is the critical juncture. At that time, the doctor was engaged, he was going to get married. This fact was disclosed to his fiancée. He questioned it, he challenged it. This is his right to privacy. Why it was disclosed? Now, we have to weigh it on the balance. We have on the one side of the balance right to life of the fiancé, and on the other hand, right to privacy. Which one is more important? I think everybody will say right to life. And I must tell you, right to privacy is merely a component of right to life, which is on the wider platform. And apart from that, one very, very important right where in fact, nature has helped us during COVID-19. There was repair of nature to some extent. Otherwise, we are suffering because of pollutions. I'm talking about right to live in healthy environment. I can't go into details. I just want to tell you that we have to behave like good citizens, performing our duties. When we are talking about that, I want to live in healthy environment. You also want to live in healthy environment. And even though we have a concept of sustainable development goal, I would like to tell you after the Paris Agreement of 2015, there are sustainable development goals to be fulfilled by 2030. And if we read these 17 sustainable development goals, they are nothing but human rights. Zero poverty, zero hunger, sustainable cities, taking care of women health and whatnot. Now, that means we have to think of our environment. We have so many decisions. We have there endless MC method decisions. We have more than 100 this Godavarman cases. But I just want to refer to one case because I know we have to interact also. One case that is Indian Council for Enviro Legal Action versus Union of India of 1996 and then again in 2011. This is the story of village Bicheri in Rajasthan, where some industry was opened. Industry was dealing with a very hazardous substance, H acid. Consequence was that the discharge discharge in the water bodies on the land. And ultimately, it was found that those water bodies, complete flora, fauna damaged, not fit to be consumed by the human beings, water bodies not to be used by human beings or even by cattle. So this public interest litigation was before the Supreme Court when directions are issued to the government to get the sludge cleared. Directions are given by the government. Instead of clearing the discharge, the industry further spread it. And then, of course, the question was claiming compensation and imposing fine for bringing status quo. Instead of paying it, the industry, like any cantankerous litigant, went into litigation. Litigation continued up to 2011 when Supreme Court said that this is not done, and a fine of more than uh, 34 uh, crore something and with compound interest was imposed. And we have so many decisions nowadays. National Green Tribunal imposing 100 crores for violations. And I can remind you of 1979, the case of Ratlam municipality, where the municipal corporation, instead of doing something for closing the drainage system for which request was made, petition was filed, they went into litigation and ultimately before the Supreme Court claiming contending financial constraints. Justice Krishna, you said, had you used little money from your treasury and used Shramdan from the people, by now everything would have been set right. And this is the mental set. We have provisions under the Constitution, 15 clause 3 for women, for children, Article 23, 24 especially for children. And at the same time, so many laws are there. JJ Act, we had the new JJ Act of 2015, and where we talk about citizens, children who are in conflict with law or need special care and attention. Number of issues are there regarding child homes, treatment to them, child children courts. I had been a member of Chandigarh Commission for Protection of Child Rights for a period of 4 years. I know what kind of hostility we faced in the hands of administration, stakeholders for the protection of child rights. I can just give you one instance. In one summon, we questioned taking the child as well as accused in the same police van. When asked, the reply was, we did not have any other vehicle. So we can't make excuses when there's a question of human rights. Women rights, we have so many laws. I don't have time today to talk about all the laws. We talk about PCP and DT Act, where you can't abort the fetus just because it is a female. We have the Dowry Prohibition Act, we have Sati Act, we have Indecent Representation Act, prevention of this ITPA, and we have Protection of Women from Domestic Violence Act, the Sexual Harassment of Women, Prohibition, Prevention and Redressal Act of 2013. I can refer to Vishaka's case, and Vishaka's case where guidelines are issued for the protection of women from sexual harassment at workplace. Mockery of the situation that it took how many years? 16 years to pass a law, even though the operative part of the judgment said these guidelines stand as law till law is passed by the legislature. But I would just appeal to the teachers, the faculty members who are attending this refresher course, that we have to teach the practical aspect. We have to understand We have to be role models. We have to tell laws are to guarantee, constitution is to guarantee fundamental rights, human rights. This is very specific about the women rights. The rights which are given under different laws like Dowry Prohibition Act or Protection of Domestic Violence Act or Anti-Sex Harassment Act, these are being misused like anything by the women. We are at much better platform, I can tell you, after the decisions of like this Navteej Singh Johhar's case or Joseph Shine. When I'm talking about the question of adultery, Joseph Shine, Navteej Singh Johar, when we talk about all the rights of the homosexuals or LGBT rights, rights of transgenders in Nalsa's case of 2014, I don't think time is enough to talk about all kinds of human rights. But I can simply say the best human right is be a human being and consider others as human beings. I can share with all the participants here that I'm a poet by heart. I might not be able to tell in detail about the human rights, but you'll find when I just speak my words in Hindi, what are human rights? बहुत इच्छा है तुम्हारी मानव अधिकार पढ़ाने और सिखाने की. बहुत इच्छा है तुम्हारी मानव अधिकार पढ़ाने और सिखाने की, मगर जरूरी है पहले अपनी करनी को दिखाने की. मगर जरूरी है पहले अपनी करनी को दिखाने की. क्या किसी दर्द की कीमत सिक्कों में आंक सकते हो? क्या किसी दर्द की कीमत सिक्कों में आंक सकते हो? क्या किसी टूटे हुए पुष्प को टहनी में टांग सकते हो? क्या किसी टूटे हुए पुष्प को टहनी में टांग सकते हो? पूछो उनसे जाकर, पूछो उनसे जाकर जिन्होंने नारित्व को दुत्कारा घर की दीवारों में. पूछो उनसे जाकर जिन्होंने नारित्व को ललकारा दुत्कारा घर की दीवारों में. या तौहीन की आंचलों की सड़कों पे या बाजारों में, या तौहीन की आंचलों की सड़कों में या बाजारों में. जा ढूंढ कि बचपन कहाँ खो गया. जा ढूंढ कि बचपन कहाँ खो गया. किसी ढाबे पे चौराहे पे या अनाथालय में जाके सो गया. किसी ढाबे पे चौराहे पे या अनाथालय में जाके सो गया. भेदभाव दूर करने को संविधान के पन्ने भर गए. भेदभाव दूर करने को संविधान के पन्ने भर गए. कानूनों के पहरे लग गए, जुल्मी जेल में भर गए. कानूनों के पहरे लग गए, जुल्मी जेल में भर गए. मानव अधिकार, मानव अधिकार अंतरराष्ट्रीय ही नहीं राष्ट्रीय पहचान भी मिली इन्हें. मानव अधिकार अंतरराष्ट्रीय ही नहीं राष्ट्रीय पहचान भी मिली इन्हें. चाहे हो अपराधी मानवता के तराजू में तोला इन्हें. चाहे हो अपराधी मानव अधिकार के तराजू में तोला इन्हें. जीने पढ़ने घूमे कहने न कहने के हैं अधिकार. जीने रहने पढ़ने घूमने कहने न कहने के हैं अधिकार. मैं एकांत चाहूं या चाहूं ना चाहूं तुम्हें नहीं है कोई सरोकार. मैं एकांत चाहूं, राइट टू प्राइवेसी. मैं एकांत चाहूं या न चाहूं तुम्हें नहीं है कोई सरोकार. कहो कि, कहो कि मैं महसूस करना चाहती हूँ. कहो कि मैं महसूस करना चाहती हूँ मानव अधिकार. केवल स्वप्न ही नहीं साकार देखना चाहती हूँ मानव अधिकार. केवल स्वप्न ही नहीं साकार देखना चाहती हूँ मानव अधिकार. एंड द लास्ट वन, जाओ जाओ कह दो अपने अपने विद्यार्थियों को. जाओ कह दो अपने अपने विद्यार्थियों को संभाल लो कमान. जाओ कह दो अपने अपने विद्यार्थियों को संभाल लो कमान. अब तुम्हें ही लाना है, अब तुम्हें ही लाना है वापस हर मानव का सम्मान. अब तुम्हें ही लाना है वापस हर मानव का सम्मान. Thank you and God bless all of you. Now, any question, any queries invited. Thank you, Renu. Thank you, Mamta. Thank you. Thank you, everybody. Thank you. Thank you so much. God bless all of you.
Good afternoon, ma'am.
Good afternoon, Beta.
This is Anbarasi from Tamil Nadu.
Yes.
It was a wonderful presentation on human rights, ma'am. Thank you so much. My question is relating to role of human rights education as a part of school education curriculum or college curriculum. Why hasn't the Parliament taken any step relating to the importance of inculcating it into the syllabus, ma'am? It's a necessity and it's a hard.
It's a very good question, in fact, and it becomes more relevant in COVID-19 pandemic issues. I must tell you that it is not always a necessary that we have the nomenclature human rights. Human rights are being taught in one form or the other. I can share with you my experiences only. I told you beforehand that I had been member of Child Right Commission. So almost every day we used to, for some time, we used to send our experts or counselors to the schools to make them, the children, aware of the child laws like POXO, good touch, bad touch. And at the same time, we used to have the meetings and the workshops with the principals and the teachers, administrators, other people also. Because I can give you one example of Section 19 of POXO Act. It talks about anybody who comes to know about any such abuse of the child, any violation of child right, must immediately and be punished. So this is not that we that there is a subject human rights, right? And second thing is, in every school, value education is taught. Value education through different stories, different ways. What we teach values. What and but following the values. And I might have my own thinking, but I am sure if the families, if the mothers, they teach values, if the schools, they teach values, I think we don't have to tell them this is this kind of violation of human right, that we don't have to tell the students that rape is violation of human dignity of women. But of course, you are right to some extent that this can be made part of the curriculum in one way or the other. Because ultimately, what we require is not merely telling them to cram something without understanding the necessity, without understanding that they can also part of this human rights revolution. Apart from that, if I refer to college education, of course, this was at the behest of the apex court, that this environmental education was made part and parts of curriculum, even though merely passing, it was not score was not included in the total score, but they were taught about the environment issues, and this is one of the human rights. Now, how many human rights are included here? Your quality life, your quantity life, your health, your well-being, your positive thinking, and of course the mental health. And at the same time, in the colleges, they are being taught about disaster management, traffic rules. Now, directly, indirectly, everything is related to human rights issues. And I must tell you, it has become a fashion and trend nowadays in every school, There has to have anti-sex harassment committee, internal complaints committee. There are otherwise committees in the grievance committees in the schools where all these human right issues can be addressed. Because if I am bullied, I am a school student, I am bullied by my co-student, this is violation of my human right. Same is true about the colleges. There are different committees which are performing this function. Regular lectures are there on this issue. But it's not that I deny what you want to say, that in human rights as a subject in express form, there is no harm at all. But my dear, the purpose is to teach and not to overburden the students with the number of subjects to be added. Thank you.
Thank you, ma'am. Thank you so much.
Hello, ma'am.
Hello.
This is Jay ma'am from Bangalore. I just want to,
I can't hear you properly.
hello, ma'am. Can you hear me now?
Yes, now it's better.
Yes, ma'am. So my question was, most of the time is human rights and social with common law. Am I audible?
No, it's disturbing in between. The voice is cutting.
Hello. I believe, sir.
Can you write? I can then read on the screen if
Yes,
I
yes,
can't
ma'am. I'll
hear
do
you. Uh-huh.
Is it audible?
Yeah, you are talking
Madam.
about that this is treated as a soft law. Now, in which sense you want to say it is a soft law? If you can recollect, when I started, I said we take it very lightly, this human rights subject, because we find it interesting. Interesting in the sense, this is not interesting, in fact. Why it is not interesting and why it is not soft law? The reason being that we want to find a solution for somebody's suffering. And when we are referring to the story of suffering, when we are referring to the laws pertaining to the sufferings, when we are talking about the punishment because of suffering, and when we are talking about that in spite of punishment, no relief to the victim or the victim family. I hope we have not forgotten the acid case. We have not forgotten the Nirbhaya issue. So can we say this is a soft law? This is not a soft law. This is not a soft issue. But it is we who take it as a soft law. We take it very lightly just to teach this is what is included in UDHR, this is what is included in international covenants, this is the law, this is the composition of the committees. What the committees are doing, are we analyzing? What different stakeholders are doing, are we analyzing? This is not so. I hope it is clear to you. Hello.
Ma'am, good afternoon, ma'am.
Hello.
Ma'am, this is Kritika from GLC Chennai, ma'am. My question is, what kind of tools can be used to impart the practical aspects of human rights, ma'am? Like we can encourage the students to go for internship like State Human Rights Commission, National Human Rights Commission, or get involved with some NGOs. So likewise, what all the other kinds of tools that we can use, ma'am?
Yes. As I also said, that this can be part of your curriculum, that you may send your students for, say, give them projects and send them on camps, on living situations, like if the miners issue is near some mine, in some issues on some construction of dam, or issues relating to some national parks, right, protected areas. You can send them near the tribals to see what are their problems. Like now in this COVID-19 issue, some issue of constructor workers, laborers, and we were reading in the newspaper what happened. We do talk about women rights, women delivering on the roads. So our students, there can be given the projects as such to study and come with the data which can be analyzed. This is part of curriculum. Beyond that also you can work. You can have pro bono clubs in your university, in your department, in your college, where you can engage the students in different human rights issues or social issues. And students are really enthusiastic. They have the enthusiasm and see the chain. You are motivating them. They want to work. They will forcibly take a motivation from their parents. And this is how a chain will be constituted in the society. I hope it is clear.
Yes, ma'am. Thank you, ma'am. Thank you so much.
Good afternoon, ma'am. Good afternoon, ma'am. This is Dr.
Good
Devanshu Srivastava, and I'm
Yes.
from Jaswal, Lake City University, Bhopal.
Please.
Ma'am, first of all, I'll just take a minute for the lovely poem that you just said. So
Thank you,
that
Vita.
was
Thank you.
an inspirational
Thank
thing,
you.
and I guess we are just waiting for the recording of this session that we can replay those words from your thing. And also, thank you, ma'am, for the lovely ideas where we can relate human rights. I myself, being a professor of intellectual property rights, but very much I got some new insights and where I can relate human rights with IPR as well.
Yes, it
So,
can be.
yes, ma'am. So, thank you so much for that lovely insights. And I would also like to compliment the organization that NLIU has started, the labor thing
Yes.
across. It was
Mazdoor Mitra.
Mazdoor Mitra, exactly, ma'am. So, all student-led thing, and I guess that was it even got a mentioning indirectly through your speech as well. So, thank you so much, ma'am, for that particular thing.
Thank you all and God bless all of you.
Thank you, ma'am.
Thank
Good
you.
afternoon, ma'am. I'm Dr. Yash Tiwari from Jagran Lake City University School of Law. I have one question, ma'am.
Please.
First of all, I must tell you that this session was quite informative and very interesting for me. Ma'am, during the days of pandemic, now everything has been changed. The mode of education has been changed. So now the school students are supposed to attend their lectures virtually. So don't you think so that this is the violation of their human rights, because it has many diverse adverse effects as well on the students?
Very good question in this critical time. I would like to say one thing, and time and again I'll repeat it. See, we had violation of pollution of environment. Then we tried to bring out a balance, inventing a term sustainable development, right?
Yes.
And now this pandemic is there. We know that, and I only said there's a fundamental right to education, especially for the school children. Question is, are we providing education? Answer is yes, but not through the classroom mode, through online mode. And I do understand this is not a good mode for the students, especially pre-primary students. I think for pre-primary students, most important thing is they must understand what is life, enjoy life, lay the foundation of their personality instead of online teaching, preparing their assignments, appearing in the tests. But here, the system is not at fault. We are helpless. We have to find a solution. We cannot say the human right is violated. No doubt, I understand. Strain on eyes, mental health issues, anxieties, all are increasing. But I'm always optimist. I always say, ये भी गुजर जाएगा. In fact, I could have shared with you my views. I wrote a poem on Corona, but I won't take time to talk about it. And I just refer to this system as Suni Suni si kakshaएं, Sehmi Sehmi si imarteं. But ultimately, we who belong to this system of education, we have to find a solution. And it is open to every teacher present here. If you have any solution for this, come out with this. This is the time when we have to change our. We don't know how long we have to live with this corona and how long we might not have the regular classes where we can have one-to-one interaction. At least we have some solution that. But still, I would like to make one statement. Guru bin gyan nahi. Online teaching, like I'm also, I can share with you, admit before you, I am speaking before the screen. Sometimes I see some face, otherwise I am not seeing any face. So a kind of inspiration, a motivation for the teacher is, don't think from the angle of student only. It's the teachers, their human rights are being violated, and many are things which cannot be taught online unless we have all the facilities. And for those facilities, I think most of the educational institutions or universities or schools, they'll talk about the financial limitation. But my request to all of you, we must learn to adjust, accommodate, and adapt, whatever the situation is. If we remain strong, we have to control our mental health issues. This is the time we have to think about our families, because family is the best school in the whole earth, whole world. Mother is the best teacher. So learn, because otherwise in your daily routine in schools, colleges, universities, you don't have the time to interact with your families. Learn and have the best bonding with your family. Thank you.
Thank you so much, ma'am, for such a beautiful answer. Thanks a lot, ma'am.
Ma'am, good afternoon, ma'am.
Good afternoon.
Good afternoon, ma'am.
Good afternoon.
I'm Triveni Prabhakaran from Government Law College, Trichy. Hello, ma'am. Am I audible?
Please.
I'm
Yes,
Triveni
yes,
Prabhakaran from Government Law College,
yes,
Trichy. Ma'am,
yes.
I got a wonderful lecture today from you. I had
Thank
only
you.
one doubt during that lecture, that how the
Please,
property can
please.
be a human right without having the status of fundamental right in Constitution.
Absolutely, absolutely right. This is what was held by the Supreme Court. Now we discuss it in a different sense. Property.
Fundamental right in Indian
What is
Constitution.
property? Property does not mean acres of land. Property does not mean bungalows. Property may mean, for a farmer, a limited piece of land for his survival, because he has nothing to depend upon for his livelihood. Property may mean one room with four walls, one roof. I told you, shelter. So in this sense, this was taken. It's not, it's human, because I said in the beginning only, all the human rights are not fundamental rights. So it is not necessary for a human right to be a fundamental right, because when it is not a fundamental right, you may not have a constitutional remedy for that. But of course, a request can be made to the welfare state. Now I tell you about one decision. I'm not. It was Umed Ram's case in 1985-86. What happened? Petition was before the High Court of Himachal Pradesh. that in the interiors of Himachal Pradesh, there are not proper roads constructed, and because of non-construction of roads, they don't have access to livelihood. Because if they have to go to the place of where they are earning their livelihood, they need roads. High Court of Himachal Pradesh directed the government to construct roads. Government said, we need to have budget sanctioned from the legislature. There's a process. But High Court of Himachal Pradesh said, you create for it. That is your headache. Matter went up to the Supreme Court. Now here Supreme Court said, no doubt, this is the need of the time. Now this is a human right. Right? This is a human right. Now which becomes part and parcel of fundamental right to life. Why? Because there is a chain. Life, shelter and livelihood. Right, access and livelihood. So only a suggestion was made by the Supreme Court that is a need of the time which must be considered. Now, here I want to tell you that initially we had this right to property also as a fundamental right. Now, if the Supreme Court says it is merely human right, that means you can't enforce it. But still you can cherish it. You can make efforts for it. There may be statutory provisions for protecting such right. And we do not know what is going to happen tomorrow. Tomorrow there may be a change again. Because what were the circumstances? Again, those were the circumstances again when the interest of the small landowners, interest of the farmers, those were protected, and certain economic principles were to be applied, that if you have just small land holdings, then number of issues are there. So that was the reason, because it could not be protected. Any decision on land reforms could not be taken by the government because of this fundamental right. That is why,
Yes, ma'am. Thank you.
God bless you. I hope it is clear to you now.
Hello, ma'am.
Thank you very much, ma'am.
Hello, ma'am.
Hello, ma'am.
Hello.
Hello.
Hello, ma'am. Good afternoon.
Good afternoon.
Ma'am, my name is Gauri Gulati, and I'm an assistant professor at Maths University, Raipur, Chhattisgarh. Ma'am, relating to child prisoner, I had a question in my mind, and that was also in my mind from 2003, ma'am. But I didn't get any scope to ask this question to anyone. But today I get the opportunity to ask this question before you, ma'am. To present this question before you. Actually, ma'am, in 2003, 2004, there was a case, that is Dhananjay Chattopadhyay. He was convicted for rape case and he was hanged in Alipur jail in 2004, ma'am. But the point which stuck in my mind was that, ma'am, Dhananjay, when he was hanged in Alipur in 2004, he already spent his 14 years in jail and waiting for the final conviction. And he was waiting for the final conviction. And 14 years in jail itself means a life imprisonment, ma'am. In such case, when there is a delay in trial, whether this will not amount to the violation of the right of the prisoner, ma'am?
A number of issues are involved in your question. One thing is, we don't talk about child prisoners. This term we don't use. See, one term we use is juvenile, right?
Yes, ma'am.
And we send the children who are called, we call as juvenile after age, we send them not to prisons but to juvenile homes. In fact, we relaxed this aspect also after this Nirbhaya murder. Criminal law amendment was made that we may change our attitude and consider the children between the age of 16 and 18 years differently if a heinous crime is committed and what kind of state of mind was there. Then regarding the issue, keeping in the jail for 14 years and then hanging. This is very, very important and touching issue. And that is why I touched all those aspects, that if there is delay in the execution, Now, this principle has to be known because we simply think that there is delay in the execution, so it must be converted to death sentence. And this, the Ranges issues can also come into question in the same manner.
Yes,
Now,
ma'am.
here we have to think on different terms. One is what caused the delay? Whether the mercy petition was pending for years, not decided, or different tactics are used by the offender, the convict, to delay the execution. This is very, very important. In fact, in Kasab's case, if I don't, it was the judgment by Justice Deepak Mishra. You know, here this final mercy petition was also dismissed. Why? His contention was it is my first mercy petition. Well, if we go into the details, see, in the news item, nothing comes in detail unless and until we who study law, who are the students of law, we teach and we read the judgment as a whole. Then we can come to know about the facts of every situation. That how already his brother had filed a petition which was dismissed. So time and again you are filing. You file before the governor, then you go to the president, and you keep on. And then another fashion has come. Supreme Court in 2002 invented a term curative petition. I think all of you know Rupa Shokurra versus Shokurra in 2002. So then another fashion is file curative petition. So if tactics are just to delay, I think no mercy is required. But so every case has to be decided on that particular facts. Otherwise, also we have so many decisions where, like Rudra Shah, for 14 years kept in the jail. Upadhyay's case for 30 something years kept in the jail. So I talked about under trials, speedy trials. This should not be done. But I want to admit there is a lot of gap between preaching and practice. Decisions by the Supreme Court and when implemented. I gave you the example of handcuffing. I hope it is clear.
Yes, ma'am.
Hello, ma'am.
Yes.
Hello, ma'am. This is Sham Chakraborty from Tripura Government Law College. Ma'am, my question is, ma'am, it seems judicial activism has increased in the post-COVID-19 time. And it's quite obvious also, ma'am. But at the same time, can we say through judicial activism, there can be effective enforcement of human rights? Because as always, the fear of judicial overreach is always there. At the same time, ma'am, we are also not living in the time of Justice Krishna Iyer and Justice Bhagawati. So, ma'am, what is your opinion regarding judicial activism in the post-COVID-19 time for protecting human rights? Thank you, ma'am.
It's not only with a post COVID-19, it's even during COVID-19. I think I was just reading that first constitution bench through video conferencing just now, day before yesterday. In fact, I want to tell you something that we have to understand judicial review, judicial activism, and judicial adventurism. Adventurism, you understand, going beyond the limits, what you can do. One very, very important question which all of you must be knowing, that is the doctrine of separation of powers, which is presently known as theory of checks and balances, that no organ can cross its limits, perform the functions of another organ or intervene in the functions of other organ. So we have legislature to frame laws, we have executive to implement the laws, we have judiciary for judicial review, reviewing the laws, the acts. At the same time, gone are the days when we could not talk about judicial legislation. I have so many examples where the judiciary has given direction, like Vishaka's case I talked about, like D.K. Basu, where we talk about the protection at the time of arrest. How many years it took to become part of the CRPC? How many times it took to become Vishaka to become a law in 2013? Similarly, there was Lakshmikant Pandey's case on inter-country adoption. It was decided in 84 and 2016. The Kara guidelines came. Now, Supreme Court can tell what it is. If there's a vacuum of law, it can legislate also. We have accepted jurisprudentially also nowadays. But when we talk about Supreme Court protecting the human rights, Supreme Court is doing it. I can tell you, after Maneka Gandhi, there's a total revolution where the Supreme Court has not intervened, whether the question of fake encounters or custodial violence and what not. But ultimately, it is the execution part does not belong to Supreme Court. It's only when this question comes to the Supreme Court, you can say this is contempt of court. This is civil contempt, this is criminal contempt. A civil contempt when is not implemented. Criminal contempt when you don't allow the judge to do something, to decide on a particular issue. He starts receiving threats. How can you intervene in the human rights issue? You and your family will be killed. Then this will be criminal contempt also. But ultimately, all the three organs of the state, they have to work in coordination. Now, human rights issue, in fact, the Supreme Court has started intervening. Now, whether it's the question of school students, whether it is the question of migrant workers or any other issue, I can share with you one thing. I'm in state of Himachal Pradesh. I'm in Shimla. Shimla was very well safe and healthy from the point of view of corona. But the government has its own limitations because for considering the economic status of the state, it was to be opened for the tourists with all precautions, all precautions. Complete guidelines are there. Still, the feeling among the people that with the emergence of tourists, there will be spread of corona and it will be difficult to contain it. Petition has been filed before the Himachal Pradesh High Court on this issue. Now the question is, there has to have balance among different organs of the state for the functioning. And if while we accepted even harm to the environment to a certain extent in the name of sustainable development, the same principle is applicable here. I understand right to life is very, very important. But of course, for the survival, we have to eat, we have to live. I hope it is clear to you.
Yes, ma'am. Thank you, ma'am.
Thank you so much, ma'am. I would really like to extend my heartfelt gratitude to you, ma'am. And thank you so much for sparing time for us and for the participants. I know this session has been really enlightening for the participants and it will indeed help them in their future classes and everything. Thank you so much, ma'am. Once again, I would like to thank you on behalf of the organizers.
May I ask one more question?
Saran College and
Hello.
Group. Yes, ma'am. You have any questions?
I have one last question, if I'm allowed to ask, ma'am, please, Professor Doctor. Ma'am, I just wanted to know, I'm an assistant professor, and I just wanted to know what happens in those times when the human rights that are being violated in a country which is not observing UDHR. For example, South Africa, Czechoslovakia, right? If at all there is a dispute of human rights violation wherein a country is observing UDHR and the other one is not, how do you make observation of human rights a binding thing upon them?
Yes, in fact, without commenting on what is happening in which part of the world, these are not the only two examples, there are many. Number one, it is the internal matter of that particular country. I think you'll react and say, in the modern global times, nothing is internal. It is affecting whole of the world. But peculiar circumstances are there. It is a question of adoption of any international covenant or declaration by any country. No, the same way, if I give you one example of India, how and what happened. I just give you one example, then you will understand that to what extent there's a scope of intervention internationally in the national affairs. No doubt, there is a violation, the matter will be raised in the United Nations, the big powers will emerge on the scene. Then of course this is the international politics. I can only pray that God should give wisdom to these countries to protect the human rights of their citizens, because this is the foremost duty of that country. We can only sympathize while being here, or if we are a powerful state, then of course we can do something to some extent only. Now, I was just giving you example. This is something very different. A question arose in 1987 in India. Decision is of McKenna and McKenzie versus Andrade Costa. Now, particularly this question was relating to equal pay for equal work. If I tell you, we were signatories to the International Covenant on Equal Pay, Equal Remuneration, and still not implemented. And the issue was the female stenographers contending and challenging that they were not being paid the same scale, same grade which was being paid to the male stenographers. If you know the law about equal pay for equal work, what is required is same skill, same effort, and same responsibility, same qualification, same job profile. Can you say male stenographers are something special and female are not? When this question was raised, and the contention on the part of the government was that we have we are lack of finances to pay to these female stenographers. I'm just talking about the effect of the international convention on any country. It is the internal decision. We know about to what extent the international law is binding and can be enforced. Thank you.
Thank you so
Thank
much.
you, madam.
Thank you so much, ma'am. I would like to thank you on behalf of the organizers, Iswar Saran PG College, Prayagraj, and Droit Penale Group, a unit of Arjun Memorial Society, for sparing time for us and for the participants. Thank you so much, ma'am. We are really grateful and we are honored to have you, ma'am. Thank you so much, ma'am.
Thank you, everybody.
Thank you,
Thank
ma'am.
you all. God bless all of you.